Although as jurors you are encouraged to use all of your life experiences in analyzing testimony and reaching a fair verdict, you may not communicate any personal professional expertise you might have or other facts not in evidence to the other jurors during deliberations. You must base your discussions and decisions solely on the evidence presented to you during the trial, and that evidence alone. You may not consider or speculate on matters not in evidence or matters outside the case. Caveat: the Court of Appeals has urged trial courts to provide the above charge to alleviate the potential for improper juror activity. People v. Arnold, 96, New York 2nd, 358. If a juror, upon inquiry in voir dire, indicates an inability or unwillingness to follow the above instructions, that provides grounds for a challenge for cause. Id. Based on People v. Mora, 94, New York 2nd, 569, the jury must reach its verdict solely on evidence received in open court, not from outside sources. People v. Arnold, 96, New York 2nd, 358. Conflicting expert medical testimony. Two jurors who were registered nurses informed the other members of the jury that in their medical experience and estimation, the reported volume of blood loss could have caused the victim's death. The court stated that in past cases examining juror misconduct, it had determined that the complained of conduct must be something more than an application of everyday experience, for that is precisely what peer jurors are instructed and expected to use in their assessment of evidence. Id. The court observed, however, that a grave potential for prejudice is present when a member of the jury, a professional, and shares expertise to evaluate evidence and draw expert conclusions about material issues in the case that are distinct from and additional to evidence adduced at trial. In this situation, other jurors are likely to defer to the expertise and evaluations of fellow professional jurors, thereby diminishing consideration of their own everyday experiences and judgment and the evidence actually adduced at trial. The court concluded that reversible error can occur where each of the following three elements are present. 1. A juror conducts personalized assessments not within the comments or common ken of juror experience and knowledge. 2. The assessment concerns a material issue in the case. And 3. The juror communicates those assessments to the rest of the jury panel as if they were evidence. Id. The court acknowledged that the knowledge and experience of jurors who happen to be professionals of every type in everyday life are brought in some part with them into the jury service and deliberations. Jurors may not, however, communicate their professional assessments to the other jurors because it would violate the rights of litigants to have their cases decided only on the evidence adduced, and would substitute these jurors' own professional opinions in place of expert proofs adduced at trial. Id. The Court of Appeals has strongly encouraged trial judges to remind and caution prospective jurors that they are required to decide the case solely on the evidence presented whenever a prospective juror indicates a possible motivation to inject non-record facts into the deliberations. People v. Arnold, Supra. In People v. Arnold, 96, New York 2nd, 358, the court noted that the fact that a juror had studied domestic violence in college did not demonstrate that she had specialized knowledge that would enable her to exert undue influence on her fellow jurors in a case involving defendant's assault of a former girlfriend. Indeed, the court recognized all jurors bring their background, education, and predispositions of varying intensity when they enter the jury box. The Court of Appeals noted that New York does not require jurors to check their life experiences at the courtroom door, and that one of the goals of New York's jury reform was to eliminate all automatic exemptions from service, bringing to the jury room a wide array of individuals with specialized knowledge and training. People v. Arnold, the court noted that People v. versus Mora, 94 New York 2nd, 569. Can you hear me?
Yeah, tough. It was tough.
Oh, you gotta concentrate.